4th work session for the Douglas County Board of County Commissioners. Today, our topic is eviction prevention and diversion initiatives. As with all of our work sessions, they're for information purposes only. We don't take any action after our work sessions. We also don't take any public comment. If you'd like to provide public comment, we invite you to our 5:30 business meeting. We have a bit of a light agenda, so you will probably be it for the business meeting at 5:30 if you want to provide public comment on that. And with that, I'll turn it over to Jill Jolliker to get us started.
Thanks, Commissioner. This study session was requested by the Commission as the follow-up to our budget conversations. There were some budget requests that came up that were related to activities that were related to this topic. So the Commission asked the County Administrator's Office to follow up and provide you all with a sense of what's happening today in terms of eviction prevention, diversion activities. So we've got a really great group of guests here. And before I talk more, I want to make sure that they all have a chance to introduce themselves. And I do hope that I think a majority of today's session is a conversation. You've got some great folks here, so you can ask. I anticipate today to be a lot of discussion, question and answer, and we can follow up with any additional details. But I'll pass it to Bryn to follow up. Yes.
Hi, my name is Bryn Blair. I'm the managing attorney of the Topeka office of Kansas Legal Services. And of course, one of our 5 county regions is Douglas.
Doesn't turn all the way down. I'm Sam Allison Natale, Executive Director of Kansas Holistic Defenders.
Hetty Pierce Armstrong. I'm one of the civil attorneys with Kansas Holistic Defenders.
And I'm Adelita Mendoza. I'm the Eviction Resolution Coordinator at the District Court.
I'm Kristen Egan. I'm the Douglas County Housing and Human Services Program Manager.
And we have Shelby Ostrom is here from the Lawrence Douglas County Public Health. She put together one of the handouts that's in your packet. If there's questions that come up related to some of the research that she's done and related to that hand up, we can have her come up here as well. But she's sitting there in the first row if we want to have her up. So in your meeting packet, there's a lot of information. We wanted to make sure that we were starting with providing background on just what does the eviction process look like. So what's up on the screen, and there's a few slides that were in the packet. And I kind of want to test out how many of those you all want to go into. But I think for starters, this first slide lays out very nicely a big picture of what the eviction process looks like. And I know we've got some subject matter experts here that can talk about the specific elements of this. But this slide and the slides that are in your, the other slides that lay out visuals of this process, these actually live on the Douglas County website, on the Housing Stabilization Collaborative website, thanks to the work that our program managers have done in the past to make sure that we are providing Douglas County tenants with as much information as possible about how does this process work. But you can see at the very top here, when the landlord serves tenant a written notice, the tenant, if we just start on that left-hand side, you can see that the tenant has the chance to resolve the issues within the time frame outlined on that notice. And then in that case, that would be considered resolved and the eviction would not go forward. And I think where we're going to spend most of our time talking today is where they're not resolved. And I think there's a lot of issues related to how could we keep more tenants on the left side of this environment, and prevent them from being on the right side of this chart. But when those issues are not resolved, the landlord files the complaint with the court. And you see as you go down the chart, the court serves the tenant with a summons and a complaint, and it can go either way. The tenant answers. If we go to the right, the tenant answers. They either admit to charges, they deny their charges. If they admit to charges, they go over to the writ of restitution issued by the court. And then the tenant has 14 days to move out. And then the sheriff is required to remove the tenant within 14 days of that writ of restitution being issued. If they deny the charges, hearing date is assigned, the hearing takes place on an assigned date, and the outcome varies depending on what happens in the hearing. So I think, again, there's some additional slides that we can dig into, but, in terms of how the tenant shows up, does the tenant show up to that answer docket? Do they admit to the charges? Do they deny the charges? These are some of this is where I think some of our partners come into play, and it might be a nice opportunity to, in your meeting packet, you've got information about what is currently happening at the Douglas County Self-Help Center related to pre-file eviction diversion. You've got information about the work that Kansas Holistic Defenders is doing with, I believe, 2 grant programs that they have currently. And then you have information about what Kansas Legal Service is doing in partnership with the Self-Help Center, but also just what is the footprint of Kansas Legal Services in general as it serves Douglas County. Again, we tried to provide you all with information so you have a sense of who's doing what and for whom, and what are the the outcomes associated with that in your packet. So I want to pause there, and if there's questions sorry, Kristen, you poked your head out and that reminded me. I thought it was important to have Kristen here as a representative of Douglas County Housing and Human Services. She helps us administer the rent utility assistance program. When that program was first set up, the county designates $350,000 in general fund support for rent and utility assistance each year as part of the budget process. And we know that we considered those dollars to be eviction prevention when they were first allocated. And I think what's hard right now is that it's hard to know whether or not we are truly preventing evictions with those funds. The demand for those funds are so significant compared to what we can and we can't do. And the partners have worked hard within the Housing Stabilization Collaborative. Those are the partners that come alongside Kristen and help provide us advice on how we can most effectively use those dollars. Right now, we are only able to serve a very small number of people, and it's folks that have an eviction in hand or have their notice in hand, and we still don't even know whether we are truly preventing eviction. So I thought it was important to have Kristen here just to give you a sense of what is she seeing on the regular, when she's hearing from tenants, when she's hearing, she hears from landlords too. So you've got a good amount of folks here. So I want to dig into questions discussion at this point.
So as I went through the packet and I'm noting 3 days, 14 days, my assumption is that that is set by the state of Kansas, and those are the rules, right? Okay.
Go ahead if you want to follow up on that, Hetty.
There is just a small carve out that would be federally set by a provision of the CARES Act for 30 days notice in some instances, some limited instances.
Where certain properties are federally backed or received COVID money, there is a longer window, which has been very significant for some of our clients for whom that applies. But yes, the 14 days and the 3-day schedule is set by Kansas statute.
So I might ask, we have information in the packet, but it might be just a good moment to, I might start with Adelaida. Would you like to talk a little bit about what historically has the programming looked like with self-help, and then we'll move on down through KHD and down to KLS?
So I am present at the district court at one of the most vital stages of the eviction process. We tend to have the most interaction with tenants when they appear at the answer docket. So that's the pivotal point where whether they admit or deny to what's listed in the petition. I connect them with resources at that time. So if it is due to non-payment of rent, we connect them with Housing Stabilization Collaborative, make sure that they know about that resource. In some cases they do and are connected with that resource already. In the past, when Catholic Charities had funding, we also connected tenants with them. Right now, they don't have additional funding until September, is my understanding that they'll get more funding. We try not to lead tenants to dead ends and try to encourage them to to go to resources that are available, so that way they're not discouraged. We do have to sometimes re-encourage them to apply to HSC again. Just because they're not selected the first round does not mean that they're not eligible to be selected again. At that moment, what I do is the map that you see in this binder, I refer to with, I have a binder that I show the tenants and go through the timeline with them, just so that they know what's going on and how much time they have, because that's a vital information for what stage that they're encountering. I also give them the opportunity, I give them, I make sure they understand they have the opportunity to speak to Kansas Holistic Defenders on that day and try to get a summary of their situation, so I can get that before Hetty or Stephen Park, who's also part of Kansas Holistic Defenders. Most of the time, that tends to be the bulk of my contact with tenants. Sometimes it is with tenants who've already gone post judgment and want to know if they have any additional options. At that point in time, I just refer to community resources and let them know that the only way to pause an eviction would be to put up a bond. And if someone had the funds to put up the bond for an eviction case, then they would have the funds to pay their rent. So unfortunately, most times there is no solution at that point in time. So sometimes it's just being a compassionate ear and trying to direct to what resources I can.
Thanks, Adelina. Do you get much contact from tenants ahead of that answer docket? Like in your time so far, have you noticed that you get walk-ins that may have been referred elsewhere or learned about self-help before that answer docket date?
I do sometimes. So sometimes I get contacts before the eviction writ has even been issued. And we do refer to mediation in that situation. Unfortunately, it does not always seem that landlords want to participate, since we have a voluntary program. But we do get contacted from different tenants. In some cases, it's not always related to non-payment of rent. Sometimes it's unfortunately a choice of the landlord not to renew a lease for a tenant, and that's a right that the landlord has. And they just want to make sure that they understand that is final. In some cases, tenants just want to know, if I pay my rent within these 3 days or 30 days, will I be allowed to remain in my residence? And those are often really some of the more happy instances where I get to say, yes, you shouldn't be having an eviction case filed as a result of this action. So yes, I do get contacted by tenants beforehand.
Thanks. And you mentioned that you, at that point, if you are contacted by a tenant at that point, pre-filing, you're able to make that referral for mediation. Though, as you pointed out, that hasn't been, those referrals haven't necessarily resulted in any outcomes because of non-participation of landlords. So on the flip side of that, do you have any data or anecdotes about frequency with which you are hearing from landlords, like specifically pro se landlords that don't have lawyers that are coming and seeking information, resources about what their rights are and whether or not mediation, maybe even asking directly about mediation or otherwise learning about it because they come to self-help or to contact you otherwise?
I do get contacted by landlords. I do. So in some situations, it seems like they've waited so long that now the debt has amounted to a lot more than, say, 1 month's rent. It's maybe been 2 or 3 or 4. And I find that by then the landlord's patience has run very thin. In some situations, they don't necessarily always want to engage with mediation because it might be that they don't have a good relationship with the tenant, unfortunately, and that breakdown is significant. In other situations, I've offered it, and I don't get a reason necessarily why they don't want to participate in mediation.
Thanks. Do you have any success stories about mediation referrals that you can share?
So we initiated a small claims landlord tenant mandated mediation program from the small claims court for Judge Glover. Judge Glover has referred 7 cases to mediation so far, and 2 have resulted in mediated agreements.
Can you color in a little bit that sort of the distinction between a small claims court and a landlord tenant issue versus an eviction filing and an eviction action?
So there might be remaining issues within a landlord tenant action. So I believe one example of one of the cases was, well, it wasn't related to eviction, but it was landlord tenant related. And it was that there was a pest issue that the tenant was responsible for paying for. And they then took the action to court so that way they could get reimbursed for costs to eliminate the pests. And then I believe maybe hotel costs as well. Mhm.
So I'm looking at the three potential things that the written notice might look like. You got the 3-day notice, the 7 or 30-day notice, the 1430. So the 3-day notice is listed as for non-payment of rent. Can you talk through like what the other forms are used for and what kinds of things are leading to eviction other than non-payment of rent?
Or so there's two other kinds. The 1430 may be for a lease violation. In that situation, it could be for health and safety. So in some cases, I've seen maybe like a hoarding situation. I've also seen that disturbing the peace of the neighborhood as well. For termination of a lease, a landlord can, in situations for like a month-to-month arrangement, as long as they give 30 days before the next rent paying date notice, they can terminate a month-to-month contract.
And of those that are coming through all the way through to an eviction process, are those are those generally because of non-payment of rent, or these other issues also lead into that?
I would say the majority are non-payment of rent, but I do see some rental lease violations and then some just terminations, especially with, it seems to be with mobile home parks, that there's termination of month-to-month agreements, I would say.
The question was there and then it floated right on by. Can you talk a little bit about, so a 3-day notice is sort of as you said, the most common non-payment of rent is the most common cause for an eviction action, which if we track any of that, I would love to see in the future sort of the difference between the amount of evictions filed for non-payment of rent versus the other possibility, lease violations. Were you going to respond? Did you?
We do collect that information. It's just, it takes, we're doing it line by line.
Mm-hmm.
So it just takes some time to collect that information, but we could definitely provide that at a later point. Mhm.
Great, thank you. Can you talk, I think I understand this process well, but I frequently talk with folks in the community about it and sort of the confusion around the difference between a 3-day notice and an eviction filing and a notice of an eviction with a court date. Can you talk a little bit more about that? For example, does the 3-day notice have to be filed with the court in order to be given to the tenant?
So the 3-day notice does need to be filed, but not at the time that it is served. So the 3-day notice or the 30-day notice does need to be filed with the court case once the time period has passed. It is a local court rule that our judges do require the notice to be filed with the eviction filing.
Thank you. And so just to clarify, that means somebody is receiving sort of direct notice from their landlord or property management company, not of the 3-day non-payment, for example, if I'm just looking at that, because we talked about it being the most common, that's sort of a direct notice from the landlord or property management company to the tenant, right? And it doesn't involve the sheriff yet at that point.
Correct. At that point in time, it does not involve the sheriff. Mhm.
Okay. I had another question there, but I'm gonna have to get back to it. So if other commissioners have.
So if a tenant pays the rent, can the landlord then come back and choose to cancel their lease? Do they have that option if the tenant has had a history of not paying their rent?
So my understanding is they have cured the issue. So
Okay.
the issue at hand is non-payment of rent. As long as it's paid within that 3-day period, the landlord should not move forward with an eviction filing. Of course, if a landlord were to file, then a tenant could prove that they then cured the issue at hand and provide a receipt, for example, or an electronic receipt from their payment portal.
Okay, so if a tenant has a history of not paying their rent, a landlord can't just terminate their lease. I'm just curious if you've seen anything along those lines.
I have not,
Okay.
not with that specific situation that hasn't already gone to eviction court. I don't know if maybe Kansas Public Defenders has seen anything different.
They can choose to non-renew it.
Okay, I was wondering that. Okay, so then
The
that
non-renewal
situation
just
could
is more
happen.
what we see.
Okay.
And then that non-renewal would be at the end of whatever the written lease was, or at the end of the 30 days if it's a month-to-month lease.
Correct.
You mentioned in terms of mediation that, a lot of times if there's, too many months behind that, either landlords won't participate or there just won't be participation in mediation. What are the things that would help kind of mediation be a positive experience? Is that like encouraging folks to come sooner in the process and have that discussion sooner? Or what do you see that might be helpful if we could communicate that to both parties?
I wonder if I do communicate. I have been communicating with like the Lawrence Douglas County Housing Authority, for example, to encourage people to maybe participate in mediation sooner. I recently I actually got contact from the O'Connell Children's Shelter from a case manager saying that a family was interested. So I do think that there's interest on the tenant's behalf. I'm not sure what would maybe entice the landlords, maybe if there was a promise of funds, if they participated in mediation, could be something that would entice them, because if this issue is simply non-payment of rent, then that could maybe encourage them to come to the table.
And I guess what would be a sooner timeline? I guess that would be my question.
Right when they miss that first payment, I would think. Because there is small landlords that do wait, and that I often see them 3 months later. And now that the amount has skyrocketed, they no longer have the patience or the ability to wait any longer because they have to pay their bills as well.
And how would someone know to actually initiate? Is that common knowledge?
So I have done some outreach with the Lawrence Douglas County Housing Authority, for example. And I should reach out more to maybe Lawrence tenants as well and see if they would have an interest in promoting mediation as well. But yeah, that is a good point. How education of tenants can be difficult until they find me on the Douglas County website, for example.
Because I know if I think about myself when I was younger and when I struggled to pay my bills, I would never have thought to even reach out to a community-based organization to ask for help. It would never even have crossed my mind.
Right.
So I just wonder how individuals in that place, right, at that moment, what they even think of.
And I wonder if that isn't both sides, both from the tenant perspective and education need, and from the landlord perspective and education need. Like, how do we get that information out there that, there are folks that'll help you kind of work through this before it gets so bad that it can't be redeemed. I had a question. So there's, the non-payment of rent part, and then the 1430 for some other kind of breach of contract kind of thing. Are those issues more likely to come to mediation or be successful in mediation that are not about payment?
In the situations where I have seen lease violations and the tenant has come to, and I've had an interaction with the tenant, at least one that I can think of off the top of my head, was able to file a response with the help of Kansas Legal Services, and the action didn't go any further. They were I don't think they dismissed the case, but they no longer requested an eviction hearing. It was canceled. So I do wonder if those situations would be more fitting for mediation. I just haven't had much interest on the behalf of landlords.
I wanted to, since it came up, the non-renewal is something that is quite prevalent, and I don't want to spend too much time on it. It's a way of, it's a right that landlords have to non-renew their lease. But while we're talking about a really aggressive timeline for eviction filings, there is, and correct me if I'm wrong, lawyers at the table, please, because I could be misspeaking. But I don't believe there's anything outlined in statute about how long about a time frame by which you have to give notice of non-renewal to a tenant. Therefore, a tenant might not know until the very end of their lease that their lease is not being renewed. Is that accurate?
I would say so it depends. Is there a lease or is there not? So typically a lease, it could word things as saying your 1-year lease will automatically renew unless you give us 60 days notice. And then if the tenant misses that deadline, they might be stuck in a lease, or vice versa. If it's non-renewal in terms of if it's a month-to-month contract because an annual lease has lapsed. So if you don't, in certain situations, if you've let your annual lease lapse and it turns into a month-to-month, then the landlord has to give that 30-day notice before they can choose to non-renew. So once you're month-to-month, they have to give that 30-day notice on the rent paying due date. And if in situations where it's kind of iffy on what the rent paying due date is, then by statute, it defers to the first of the month.
Okay, that's helpful. Thank you. And Bryn, to your point about the example of if there is a lease that might have a clause that says the lease will automatically renew unless the tenant provides 60 days or 90 days notice. Generally speaking, it's not common that there's a mirror clause for landlords to provide notice of non-renewal, and statute doesn't require it, correct?
Yeah, that's correct. Some of the good leases in terms of good for a tenant will include a provision about the landlord agrees to provide this much notice, but of course that's them going above and beyond the statutory requirement.
Shout out for universal leasing as an option in our future.
Commissioners, I did want to say, the questions about mediation, that policy scan document that the health department provided, one of the examples on there, the focus on mediation, you do see court required mediation in Johnson County, and that's one approach. And I think we wanted to make sure that we are providing that policy scan just to give a sense of all the different interventions that could be considered and that are at play, but that's court ordered mediation there.
And
I'm sorry.
Within that Johnson County court-ordered mediation, does it help? I mean, are there positive outcomes from that, or is it just, another step in the process?
That's part of the information that we hope to. They will say yes, there are positive outcomes. I think one of the further iterations of that policy scan that Shelby's working on is to have a little bit more information on that. And there's a great collaboration that's happening between the two health departments. And you think like health departments, why are they doing this? But we're looking at it from a social determinants of health framework. So a lot of kudos to our two health departments for working on that. So I hope that we'll have more information. Just from my one-on-one, having coffee with staff from Johnson County, what they are seeing is the population that is benefiting the most from those mediation interactions is single female-headed households. That's the population that's benefiting the most from that particular intervention.
One distinction I did want to make about the Johnson County program is that it is a post-filing mandatory. So it is only after the eviction has been filed, after the 3-day notice or whatever notice has been served. It is after the court has been formally involved.
Also important to note that a mediation is frequently happening between a landlord's attorney and a tenant rather than a landlord and a tenant.
And that expectation comes from the courts, from Johnson County District Court.
Yes.
Okay.
They've made that determination that that's what they're going to require.
And that's funded by Johnson County through the district court?
Yes.
I believe there is rental assistance attached to that, and those come from ARPA funds.
They don't have any more of it, but they did. But yes, so right now, I think they have a small contract with a not-for-profit that provides the mediation services. That's what the district court funds currently.
So from a county perspective, is it allowable for the county to have stronger protections for its tenants?
I think that's where the conversation, I think, is headed as you look ahead to early next month. Also, when those the policy options that were on that was tenant right to counsel, our access right to counsel. So that's I think that might be a nice segue just to talk to let KHD and then KLS talk a little bit about what are the interactions they're having. What is that legal? What is access to legal counsel? What's the impact that they're seeing? That might be a nice opportunity to pivot.
I can start first, and I'll talk specifically about kind of our process. So a majority of our clients, we meet at the answer docket. So our office attends the answer docket weekly. Anywhere between 3 and 5 of us are there so that we can provide brief legal service at that point in time for people to either choose to admit or deny. We take our notes at that point. And then on Mondays, we make our case acceptance decisions as to whether we'll be able to take those people on full representation, how many of them we're able to help full representation, because that's typically what we prefer. We want to be able to help them all the way through the process. But we do provide that limited legal advice at the answer docket. The thing that I think we should circle back to that's really important, that's a little bit further down in the slides, is that at the answer hearing, a court date is given to a person, and that court date has to happen within 14 days. I think right now, most of the judges are at 12 days just based off of their calendars. So it's really important that we're intercepting people at that answer docket or earlier. So we do get some referrals from outside organizations that we work with. We do have people call in. We have repeat clients that contact us before filing has even been reached, and we work to try to find a resolution pre-eviction filing, see if maybe there's a situation that's a 1430 has been served. We'll write letters or try to discuss with the landlord's attorney how we can best kind of prevent the eviction from moving forward. But like I said, a majority of our clients that we retain are happening from the answer docket and our presence there.
There's one other sort of, I guess, 2 things that I wanted to add to that. One is that, in the data that
Sam, be close to that microphone.
I'm going to get real close to it. Thank you. 2 things. One is that, our preference is to take on as many full representations as possible. And what that litigation can look like is anywhere from defenses to the eviction itself, which in many, many cases results in that eviction not happening, and a dismissal. There's dismissals that happen as a result of an agreement. We get a payment plan together, and that prevents somebody from perhaps having to relocate at all. Sometimes they relocate, but we keep the eviction off their record. We have an agreed upon relocation date that they're going to vacate. So they still have to leave, but they get additional time and they don't have this black mark on their record. Or, yes, I saw a question coming.
You can finish what you're saying. I have a question about eviction on your record.
What I mean is that, landlords typically will look at the court filings for an individual they would rent to, and it makes a difference if it says an eviction was dismissed versus whether a judgment was ordered finding that there is the judge orders the actual eviction. There's another point we may intervene, which is perhaps we don't prevent the eviction, they have to leave, and we're not able to sort of extend that timeline for them. But often we can work to make sure they are out and relocated without the sheriff having to do a forcible detainer. And so the sheriff has been a great partner with us in terms of minimizing the chaos and violence of a forcible eviction. And so I do want to highlight that there's a sort of a range of outcomes there that mitigates harm down the path. The other thing I wanted to mention was that, and we put this in the document, but we had 2 grants to do this work here. One of them was the Access to Justice grant, which was renewed. The second one was community-based child abuse prevention funding. That's ultimately federal funding that was slashed in the most recent budget. And so that funding is gone and will end on September 30th. So we are continuing our presence at the answer docket. And we are, but it does represent a significant reduction in the staffing that we've been able to provide.
Eviction record. What do you mean? What does it mean when someone has eviction on their record?
It just depends on what a person means. What we would say, a person having an eviction on a record that would negatively impact their rental record for a new landlord would be if they have an order for eviction from a judge and a writ to remove that person from that property. So typically our goal when we get a dismissal is to make sure that dismissal is the cleanest thing we can get. It's the last thing in the filing because I want to make it easy when the next person comes and rents to that person that they see this was dismissed, which means that there were appropriate grounds to dismiss it and that they complied. There are lots of people that get eviction filings that never get an eviction order, and that doesn't necessarily impact their rental record negatively.
But one thing to add there is there are other states that have formal expungement processes for evictions that have been dismissed so that nothing shows up at all. That is not yet the case in Kansas. I believe there is a bill that may be introduced to bring that here, but that would also make dismissal a very it would change the meaning somewhat of what we mean by rental record, but ultimately the entire court proceeding is a public record that landlords do access. And so what is the content of that record impacts their decisions about what they think of this individual.
I had a question. What's the root cause of not paying the rent? Is it unemployment? Is it unemployable? Other issues?
I would say often, I think most often, it's a complicated answer, but I would say most often it is one singular instance that leads to it. So someone was maybe employed at a lower wage job, and let's say they miss some time out of work for even 20 hours out of their 40 hours in 1 week. That could be a large portion of their rent. So I think that a lot of it is that. I think that there's also increasing costs in housing. So it's increasingly hard for anyone to be able to afford rental fees. I think most often I would say that most of our clients for non-payment are for non-payment of 1 to 2 months. We don't often have beyond that. We have things that are filed 10 days after a person is late. So a lot of it is just one instance that leads to a minimal amount of a person's money, which just really equals up to a lot of a loss of a person's money and leads to an eviction.
I can give you a perspective that I see often. I think that renters are very cost burdened by housing. Our wages don't keep up with the amount that it costs to rent here. So like Hetty was saying, when one thing happens, I had a guy come into my office yesterday who is being evicted. He had a family member pass away and he had to go to the burial in Oklahoma, and he's on a very limited income and he couldn't pay the rest of his rent, and how he's being evicted. And it's mostly stories like that. My kid was sick and I missed rent, or I missed work and I missed rent. It's like she's saying, one tiny instance that snowballs because they're just spending too much of their income on rent.
I just kind of wanted to add, I mean, I think it's a much larger issue than just employment being employable, non-employment. I mean, as Kansas Legal Services, a big focus of our work is domestic violence prevention and helping survivors of domestic violence. So we see countless people who have had to leave a domestic violence situation. And now that partner that was contributing to the household is no longer contributing. So would they go from a two-person income to a single-person income? And of course, that was not an anticipated expense. We also see people who have a medical issue, an unexpected medical issue. If they don't have unemployment benefits or anything like that, then they're out of luck in terms of making up that income. There's also, unfortunately, a big misconception in, I think, the public that is perpetrated through the internet, through Facebook. I see it all the time on our Douglas County and Lawrence Facebook group pages, where people get that false belief that if my landlord's behaving badly, I don't have to pay my rent. And then the Google lawyers jump on and say, yeah, do it. And so a lot of what we try and emphasize at Kansas Legal Services is public education. We try and intercept as many people as possible and say, that's not a thing. You can't withhold rent. But unfortunately, when it's all over the internet, when their friend says it worked for them, it's a big problem. And it's not, I mean, knowing that specific Kansas statute is not general knowledge.
Sam, I just wanted to follow up. You had an access to justice grant that you said had been renewed.
Yes.
And how much is that grant for?
That grant is for, I don't remember the exact number, but 85, let's say, 85,000, which covers most of the, well, about 90% of the salary, benefits, and overhead for one attorney. So what it funds is one attorney position.
And you said that you determine which cases to take. Can you walk us through what that process is for you?
Yes, and I can get on to pull up the triage process, but essentially we ask internally a few questions. Is this set for a case that is already going to trial? If it is, then we probably should not take a second one there. Are there defenses and counterclaims? Cases in which there is no defense, we can do, a brief service can be better for those because we can walk someone through the process of negotiating with their landlord fairly well. But if you have a legal defense or a counterclaim that needs to be raised, we will prioritize those. Those are more work, but we tend to prioritize cases in which there is a legal issue.
Can you give an example of that?
An example would be the 30-day notice was not followed. There's a 1430 where an issue was identified, but in fact, the landlord didn't actually give the person an opportunity to fix it. Or there are counterclaims that either the eviction is retaliatory or there are habitability issues is one that we see a lot where especially where somebody may be withholding rent for quite justifiable reasons. They're screaming that the hole needs to be filled so that they can sleep at night, and it's not. which does make the eviction process more of it gives the landlord incentive to come to the table because now both sides are able to litigate the issues in the relationship with potential damages on both sides rather than just one. So I can't pull up the procedure document right now that we looked through. Oh, and then if somebody is a current or former client, we will also tend to prioritize those, especially like intra-agency referrals from our criminal side clients that we are already in with. And then a couple other factors, if the case falls on a day that somebody's on vacation or something. But we generally try to prioritize first by when it's set for and who do we have the resources for, and then prioritizing those that have issues for litigation rather than just negotiation or finding an agreed upon move out date. Does that answer your question?
And Sam, that access to justice grant, that's a state fiscal year, is that right? So will it end in summer of 2026 or is it through the calendar year?
It runs from September to September, essentially.
Okay.
This was probably not two distinct or easily distinguishable groups, but let me try this out anyway. Do we see a difference between like what I guess I'd call corporate landlords that certainly know the process, they have an attorney, they have done this before, and kind of local landlords that maybe have a few here and there, they have a mortgage that they have to make. This is their way of building wealth, and we see that in populations of color as a way of building wealth. Do you see a difference in their ability or interest in coming to the table for mediation, or do you see a difference in how they approach the idea of eviction?
I guess we've seen vanishingly few small landlords. I can recall only a single person who, on the landlord side, who was ever pro se and representing themselves, and they pretty quickly retained an attorney. The far and away, and I don't have the precise statistics on this. It is corporate landlords. And even when there are smaller landlords, they often work through a management company that affords them essentially the same. So the owner may be an individual, but the person running the whole eviction process and managing the property is a management company. So we do see a very slim proportion of those in the overall numbers. Does that answer your question?
I guess we don't have a baseline for like of the rental properties in Douglas County, how many of them are kind of corporately owned or with a management company versus kind of just a generally local small landlord. But I'm wondering if somewhere behind that data might be that small local landlords are more likely to be solving things, mediating things before it gets to this point. And are there lessons there, if that indeed is the case, are there lessons there to learn for like how we manage that with some of these more corporate folks?
I would say, I certainly would say that there's, say, for instance, a pattern of like security deposit theft that one sees from more corporate landlords that I don't see nearly as much of from smaller landlords. Certainly that's a difference that we see. I can recall some of our pre-filing cases that we've done in which we were just able to work it out with a smaller landlord. I think it's probably anecdotally true that small landlords are more likely to engage in an informal process ahead of filing rather than somebody who's just going through every single person who didn't pay the rent. It's going up on the doors for the 3-day notice. Is that your experience?
Yeah, so I think anecdotally, yes. And I think a lot of it comes down to the flexibility of the landlord in terms of money and judgment and how much they care about money. So for example, we help a number of people in evictions with small time landlords. Their main goal is to get that rent money. They need to pay a mortgage, right? They need to pay their bills. So if they miss out on that, that's a much greater deal to them. In massive corporations, a lot of the times their priority is getting this person evicted from their property. They don't want them there anymore. The recovery of that rent money is, I would say, overall significantly less important to these big corporations. So when I think KHD would probably say the same thing when we come to the table to try and negotiate with landlords. If we offer, hey, can you dismiss the eviction if this person can hand you 3 months rent, that's a big deal to somebody who is renting out, 1-2 homes. But for a corporation, is 3 months rent, does that matter to them? That's a different question. So the negotiation and the willingness to participate, I would say anecdotally, is definitely greater with the smaller landlords.
I guess I was going to turn to Jill anyway. I guess I'm thinking a little bit about when we as Douglas County are asking local landlords to come forward and help us house folks that are trickier and to take a risk, and we'll help with some of that risk. I just want to make sure that we have kind of the whole range of landlords and not just like painting with one broad brush, because I think that sensitivity helps us in those conversations too, and I don't want that to be lost.
Yeah, and we also have, I know we have some of our not-for-profit landlords here in the room too. We have the Housing Authority and Tenants to Homeowners, and that's a great opportunity to have let's say real-time feedback about what are the things that are the tension, the frictions with them. So, yeah, I think I've heard echoes of everything that's been mentioned, and I think we have the full continuum of landlords in this community and navigating it. At the same time, I know that we still want to try to have meaningful engagement with landlords and try to come to the table on solutions, but it's very challenging on our priority populations right now, I will say. Even with the new flexible housing pool program, we're struggling to find landlords that will rent at the amount of funding that we're offering, which is comparable to a voucher, because we're positioning it as a locally funded voucher. We are struggling to find landlords that will rent at that rate, let alone work with a population that they know is going to have a lot of robust services, but when they hear who they're working with, sometimes that makes it challenging. But we do still hope to engage in a meaningful way with landlords with those incentive grants, damage deposits, things like that. Those have proven to be successful. But I do think it's also a delicate balance between another conversation I know we'll have later this fall around those supportive services and the relationship with property managers. That's really important in building trust. I did want to make sure, I don't know, Bryn, was there anything that you wanted to highlight in the work that KLS is doing in Douglas County? Before we run out of time, I want to make sure that you have a time to highlight anything.
I think it's summarized pretty well in the materials. I am the first to say that I wish that we could do more in Douglas County in terms of eviction, landlord tenant issues. And I'd be happy to talk further with anyone or send information your way. But we do have a contract with the city of Topeka at this point to do eviction defense. So our eviction work is significantly greater in the city of Topeka because that's coming from a specific pool of funding that we dedicate to that legal issue rather than the Access to Justice grant, our legal services corporation grant, that applies widely. So we're looking at evictions, divorces, expungements, the whole range. So we have found that a specific program really allows us to tailor services for that group. And I will say that statistically, based on what we've seen in Topeka, it is significantly more helpful to have an attorney. So because we catch all kinds of things that a pro se tenant's not going to catch, we come up with creative ideas and settlements that, you know, a tenant might not be savvy enough to come up with or even know is in existence. So we do what we can in Douglas County. And of course, the amount of eviction work we do is semi-dependent just on who walks through the self-help doors. But it has been that initiative in Topeka has shown us some really good data, some really good outcomes. And the pilot year was May 2024 to April 2025. That was just renewed for a second year. So we'll continue to collect data on that. But that is certainly an opportunity that I think I've made known to the self-help center, to the county, that if it was an option in Douglas County, we would certainly be willing to jump in and assist more with evictions. So, but yeah, so.
Thanks, Brent. I was going to ask you about that. Can you just give a little bit of background about how that program came to be? You know, sort of like what was the initiating conversation around that? And then a little bit of description about what the scope is. You know, are you providing full representation to everybody that you meet at the answer docket, or what's your screening process and capacity look like around that programming?
Yeah, so the contract that we have with the city of Topeka, I mean, that came from a greater initiative from the city itself to really try and address the very deep-seated issue of, you know, slumlords, retaliatory evictions. So that was an initiative by the city and the city commission, and the push for that in Topeka, that's kind of the hot topic issue that came up. So when that contract became available, you know, it was published, I guess you could say, for anyone to apply. So when we applied for that contract, we were selected. So it wasn't, you know, specially designed for KLS. That was open to anyone to apply. And that was awarded to us, basically saying it was approximately $84,000 over the course of 1 year to do services. There is not much limitation or restriction from the city on what that looks like. So of course, that covers the range of advice, limited scope representation, and full representation. The nice thing about that contract with the city of Topeka is that there is no limit on income or assets, which is unique because the Access to Justice grant and our legal services corporation grant, for us to take on full representation, there are some limitations. And when we're talking about a grant that says you can only take people at 125% of the federal poverty level, I mean, there are countless people who cannot afford rent who are above that. And then we automatically cannot even give them advice. So that Topeka eviction grant helps us give that advice to people who might be at 200% of the poverty level, but they're still struggling. So what we do in Topeka is, and it is limited to within the city of Topeka, because that's a city initiative rather than county. Now, there aren't many cities outside of the county, but Topeka is the big one. So we do have to help people within city limits. What we do at the Shawnee County Limited Actions Docket is similar to what Kansas Holistic Defenders has done at Douglas County. So we are there weekly. We triage. The clerk's office sends people to us. Sometimes our service is, here, let us help you fill out this answer form, advice, and then we have no further contact, either by our choice or their choice sometimes. And then we do kind of similar to what KHD does. We bring back any applications that from people we meet, we discuss what capacity do we have? Which ones do we want to take for full representation, limited scope, or maybe extended advice? I would say we get a lot of our applicants from that program through that limited actions docket, but we also take direct referrals from the city. We get a lot through our central intake statewide KLS application line. And then our office is one of the few KLS offices statewide that allows walk-in applications. So being in the city of Topeka, we see a lot of folks that way. So it's a wide range of services. And a lot of it, of course, we just prioritize based on various metrics, income, the person's ability to communicate, and then similar to KHD, we look at counterclaims, defenses, and then we make choices based on that.
Thank you. This question for both of you, and I know we're at 5:01, but if we can take a few more minutes. How do you each address conflicts of interest when they come up right now?
Yes. So for KLS, I mean, luckily, in the landlord-tenant eviction world, we don't run into nearly as many conflicts because so a conflict of interest is, of course, if we've helped one person or entity in the past, we can't then turn around and help another entity or person with the same issue. Well, KLS doesn't represent corporations. The majority of evictions are corporations. So that's not a big issue for Kansas Legal Services. The few times that it does come up is in those private rental situations. And unfortunately, if we have a conflict of interest, then the most that we can do is reach out to partners. So if it was a Douglas County one that looks like this person needs help, I would likely reach out to Sam and say, hey, do you want to take this? Or I would reach out to like Marilyn Harp, our former executive director who does pro bono work. We have a couple people in Topeka that might be willing to take it. But that's pretty much the most that we can do. But luckily that is not a huge issue when it comes to specifically landlord tenant.
Thank you, Hetty. So what we're now doing is opening in our system all of the cases that are going to be on the answer docket first to screen, and we put in all the parties, and our case management system will flag if the name of somebody on there is already in on our system in some way. If there's a flag, then we have to look at is there a conflict? And I will say we probably have more conflicts than KLS because we represent people in criminal matters. And so if somebody is, for instance, a witness in one of our clients' cases, which is not uncommon, then we can't represent them, for instance. And this is tricky in the domestic violence situation where we get appointed to represent somebody, and then the alleged victim there is coming in on the eviction side. And we do something similar. We say, go talk to them in those instances where we can't represent somebody. But we do have a system that flags it relatively early. So it's relatively rare that we talk to somebody who we can't talk to. We identify that up front as best as we can.
This may be a little bit harder question to answer. I'll pitch it to the crowd. Roughly, when we're talking about tenant counsel, what percentage of evictions are we catching either through KLS or Kansas Holistic Defenders and all other partners? Like, what's the gap? What's the need? And I recognize that some of that's being met through a grant that may not always be here.
So we are now, because we're capturing everybody who could show up and then marking the ones that don't, we'll have better data on this in about 3 months or so. But, both anecdotally and through the data, we're seeing about 20% of people who are being evicted show up for that answer docket, roughly. Out of say 500 evictions filed, we're showing that we met with in 2024, we're showing that we met with about 117 people. And that anecdotally seems to be true. On a day where there's 10 people on the docket, we'll probably get 2 to 3 people that we talk to. Obviously, there's seasonal shifts, and these aren't spread out particularly evenly, but I would say that probably 20 to 25% of people who are being evicted someone catches in contacts. And I don't know if that's similar to what you see.
Yeah, so I mean, I would say just in general, and I'm just speaking anecdotally here, a majority of people that get that eviction petition served do not show up. And sadly, of course, there is very little that we can do about that. And especially as a nonprofit law firm, it would be a great system if we could get a list of evictions and call the person, but we're prohibited ethically from doing that. We cannot solicit services from people. So we do see, unfortunately, a lot of people that do not show up. And I think the key to widening that the attendance at the answer docket really needs to come down to the community organizations and commission and just like the resources in the community, because the more that people know, I think a lot of people avoid answer docket because they know they didn't pay rent. They don't think there's anything else they can do. And that's something that, of course, through legal education, public education, we can really address. But we are kind of limited in talking to people that decide to show up. We also, I'm sure KHD sees the same thing. When we talk to people at that limited scope answer docket, oftentimes, I mean, if you're struggling with rent, you're likely could be struggling with something else. So oftentimes we do our follow-up, maybe even the next day, the phone might be off. We can't contact them again. So I would say that we don't talk to a majority of people who have evictions filed, but that's because of how the system is designed. So.
I'm running out of time here, but I'm going to use the chair's prerogative to ask one more question. I'm noting the city of Topeka in the discussion of some, and I know that the city of Lawrence has a rental licensing program. Are there any opportunities that you all see that exists there, whether that's through communication and education, or it just seems like that partner may be more involved than Douglas County is, while we work a lot with our partners who are sometimes landlords and working in supportive services in these spaces. We have a city that is directly involved with working with landlords. Is there any opportunity there?
Commissioner, I'll just say this came up at in one of the work groups I participated in. I think some other folks in the room, the sexual violence prevention work group, who put out a really great tenant experience survey that I'd encourage folks to read, that really echoes a lot of what we've talked about today. But that group is working to operationalize what do next steps look in terms of following up on that survey. And one of the things that we've talked about in a range of policy interventions is, can we look at programs that are currently on the books, so to speak, like a rental inspection program? And I was talking to the city's affordable housing administrator earlier this week about the current one. And I think one of the tensions is that not all, it's hard to say whether it's a fully funded program or not. Do we have enough rental inspectors going out and regularly inspecting the units? And is it structured as proactively as it needs to be? And I think that's something that could be interrogated a lot more. But I'll let others talk about that.
The short answer is yes. I do think that there is more that can be done there. We frequently see rental inspections lack teeth, even when there are egregious violations documented. Very little often comes of it. I think certainly there could be obligations as part of that rental licensing program related to how evictions are handled. But I think there are a lot of levers that the county does have access to. One being, I think, the sheriff's office, where, on the front lines often of serving, some of the important documents may include information about resources that might be available. I know Sheriff Armbruster's not afraid of providing extra information to people on that front end. So I think that, to answer your question, yes, there is quite a lot, even with the existing programs, that could be leveraged both in the education piece, in the education of landlords, and in providing accountability, especially where there may be repeated instances of violations of the duties of a landlord being enforced. And I will say, anecdotally, I've heard that Leavenworth's code inspector has been very creative and energetic in a way that I think we could benefit from.
I think that opportunity for landlord education, it is a perfect fit for the rental licensing, because they have the list of everyone who has self-identified as a landlord. So when we look at like, how do we get this information out? I think they've got it already. So engaging them as a partner.
That's true. I also just want to shout out that's publicly available information for anybody who wants to search rental licenses on the city's website. Well, sometimes you might be renting from somebody who doesn't have a rental license, for example. So it is publicly available information if you want to search that.
Thank you, Commissioner Reed. I want the more you know thing. All right, so it is 5:11. Thank you all for being here and for the great discussion. Thank you, commissioners, for your engagement. We will take a break until 5:30 for our regular business meeting.